Joining us for more from Los Angeles is Troy Slaten. He's a criminal defense attorney and a former prosecutor with the LA District Attorney's Office. Mr. Slaten, first of all, grand jury, the rules of evidence don't apply. Hearsay is allowed. Leading question is allowed. Tell us what that all means in terms of what's being presented to those folks in the grand jury now.
You know, there's an old expression that any prosecutor worth his salt could indict a ham sandwich. And that's because in the grand jury proceedings, all the rules favor the prosecutor. He gets to decide which witnesses to call. He gets to decide what evidence to put before this grand jury. All the cards are in his favor, and he controls the entire proceedings, and they're secret.
So in other words, even those people, I mean, there are several witnesses. There are people who might have been part of the police report. There are a lot of people who have claimed that they were also there that saw different things. It's likely that all of them would be presented in front of the grand jury without much difficult questioning about anybody's single credibility, right?
That's true. The prosecutor here is very experienced, Robert McCulloch. He's been doing it for 24 years. He's a career prosecutor. He's very, very experienced. He has said that he is going to put every single piece of evidence in front of this grand jury, and it's not going to be quick. He wants to do it right. He doesn't want to do it quickly. This could stretch out into mid-October.
But again, it's not that there must be beyond a reasonable doubt that a crime was committed. There must only be probable cause. In other words, there must be perhaps greater than a 50% chance that a crime was committed. Doesn't that suggest to you that in all likelihood, given the number of people who have claimed that they saw Michael Brown being shot when he was giving up, that this prosecutor will at least bring some sort of indictment and let a criminal trial figure this one out?
Look, I don't want to make a prediction about what's going to happen. I'm not in there. But what I can tell you is it's even less than 50%. 50% or more is a preponderance of the evidence. Here it's just probable cause. You have to have a really strong suspicion that a crime has occurred and that the officer is guilty of that crime. So it's a very low burden, less than 50%, and only they know. Only the people that are in that room that are going to hear that evidence will decide. And it doesn't have to be unanimous, like a criminal jury.
And the grand jurors themselves, they are sworn to secrecy, and the witnesses are usually instructed to stay silent, but there's nothing keeping any one witness who goes in front of that grand jury of coming out on the steps and saying, here's everything that I was asked and everything that I told them, right?
That's absolutely true. We've seen that in many different grand juries where there's a microphone set up and the witnesses come out and they can tell whatever they want. The prosecutors don't like that. That doesn't help an investigation. But we're going to start to hear drips and drabs. I don't think that the prosecutors will be able to keep a lid on all the witnesses who are coming before them, and we're going to start to hear and get a better picture of what those grand jurors are seeing and hearing.
And finally, what about this criticism of the prosecutor that because his father lost his life responding to a crime in which there was a black suspect, because he has so many family members who have been police officers, what about this criticism that perhaps the prosecutor should recuse himself from this case?
I think it's offensive. This is a career prosecutor. He has been entrusted by the people of St. Louis County to carry out his job. He has done it with distinction for 24 years. I think that he's able to put any personal biases aside and try and pursue justice in this case. He should not recuse himself.
Troy, I'm going to squeeze in a little more time here and ask you, you mentioned perhaps mid-October. Why would it take that long, given that the prosecutor can have the grand jury meet literally 5 days a week if he wants, and given that the threshold for bringing an indictment is so low?
It's because a lot of the evidence may not be ready. When they do an autopsy, and we've even heard from Dr. Bodden, who did the autopsy for the family, the second autopsy. By the way, the federal government is down there right now. Eric Holder, as you mentioned, arrived today, and the federal government is doing even a third autopsy. A lot of that evidence isn't ready yet. Toxicology won't come back for several weeks. There are ballistics. There are other tests that need to be done. This incident is only a week old. And so there's a lot of processing of the scene, of the evidence, of everything that needs to be completed before it can even be ready to present to the grand jurors.
And as that evidence does start getting presented to the grand jury, this doesn't preclude the federal government from bringing a separate civil rights case against the Ferguson Police Department, irrespective of what the state does in terms of a possible criminal indictment against the police officer.
That's right. They are separate sovereigns. We've heard so many times that somebody in this country is not subject to double jeopardy. You can't be charged twice or prosecuted twice for the same thing. But when it's a separate sovereign, meaning the federal government prosecuting for civil rights violations and the local state prosecutors prosecuting for criminal violations, that doesn't offend double jeopardy, and he could absolutely face 2 trials in this case.
Troy Slaten,
and then a third for a civil case.
Indeed, indeed. Troy Slaten, former prosecutor with the LA District Attorney's Office. Troy, thanks for joining us.
Thank you so much.